We have around 5,000. We simply want to go to 20,000 by 2020. So from 5 to 20,000, and our safety records are good.
Right. Thank you very much, Professor Sharma. Vij साहब, आपको लगता है कि जो हमारे सेफ्टी नॉर्म्स हैं वो काफी हैं या और कुछ भी काफी कुछ करने की जरूरत है?
नहीं, उनमें काफी करने की जरूरत है। जब हम जापान की चर्चा कर रहे हैं और जापान काफी एडवांस्ड कंट्री है और वहां पर भी मिसहैप हुआ है, तो इसमें तो यकीनी तौर पर और ज़्यादा उसमें एनहांसमेंट और उसमें और ज़्यादा तरक्की करने की आवश्यकता है, उसमें और ज़्यादा उसको सुधार करने की आवश्यकता सेफ्टी मेजर्स को।
जी। Shromani Gurdwara Prabandhak Committee today moved the Punjab and Haryana High Court seeking the prosecution of senior advocate Harbhagwan Singh for his role in the Sahijdari Sikh Row. The petition seeks the initiation of the proceedings against Harbhagwan Singh and alleged co-conspirators for false evidence and criminal conspiracy under sections 193 and 120B of the IPC. Harbhagwan Singh had told the High Court he was appearing on behalf of the centre, and the impugned notification debarring Sahijdari Sikhs from voting in the SGPC elections stood withdrawn. We are now joined in the studios by High Court lawyer Mr. R.S. Bains, in fact who is a human rights activist for quite some time. Bains sahab, do you think the SGPC should have moved the High Court in this manner?
No, I think it's a mischievous move, because apparently it's a communication mismatch between Mr. Harbhagwan Singh and the central government, and the both will sort it out. I don't believe it can actually become a case for this kind of proceedings. There is
especially when the High Court has already seized on the matter and they have said that they would be inquiring into it.
Absolutely. It is actually just for public consumption, wasting High Court time and adding a kind of, low level kind of tactics in a judicial proceedings.
So what do you think? Are they trying to get to Harbhagwan Singh, or you think they're trying to get to the people behind him, in the sense that the ones who asked him to appear and asked him to give that kind of a statement?
I think it's both. Mr. Harbhagwan Singh is actually aligned, closely aligned with Congress party, and therefore probably the SGPC actually believes that there is some kind of mischief that he made a statement, though we don't believe that, and therefore partly because of the past experience they actually they have a kind of perception that Mr. Harbhagwan may have done this kind of act and without the sanction of
but what do you think, Mr. Bains, actually happened in this case?
I think the way central government functions, the way they instruct the consuls, there is no standard procedure. Many times secretaries telephone, and we have seen time and again when there is some kind of embarrassment for the central government, they back out and make the scapegoat either the lawyer or the SSP.
So are you suggesting that oral instructions are commonplace?
Absolutely. This is the way. If I am standing counsel for any organization, I don't have to file a wakalatnama. It's never asked by the High Court. It's only the instructions. Either
but I thought senior advocates don't need a wakalatnama.
They don't even require a wakalatnama. So therefore, if somebody telephones to the central government standing counsel that look, this is to be done, he appears immediately. That's how the court functions fast. If you insist upon all kind of documentation, then the very speed of the litigation will slow down.
But in this case, there's very clear contradictions are emerging between what Mr. Chidambaram said in the parliament, yes, and a lot of other details which have now come out in the media. So I don't think the SGPC is somewhat justified in kind of moving a petition, becoming a party and seeking a probe.
No, what it is asking is much worse. If you simply ask a probe, look, there is certainly a problem, there is a mistake, there is an error, High Court hasn't actually misled. But the fact to reach to that extent that you prosecute the lawyer making a statement, that is too much. You can ask for an inquiry, you can ask for, let the High Court quickly solve the problem, rather than asking prosecution of the lawyer when there is no real intention to cheat or to give false evidence.
But don't you think in this case, whatever has happened, it kind of brings a very poor name to the lawyers' fraternity in general?
It actually brings very low, very bad, the way the lawyers, obviously, the way it is functioning, the way the central government gives instructions, the way High Court believes them, and on such baseless thing. This is something unprecedented. You don't ever believe a senior advocate will make a statement.
But don't you think in this case, the judges themselves should have insisted on a written statement or at least an affidavit, because the matter was so important?
Yes. I think the High Court acted in great haste They never wanted to solve the main problem, and therefore got a kind of escape route that this is he has said so and let's finish up the whole thing. That actually added to the problem. It was adjourned for 2 days to get a proper written instruction, the affidavit of a responsible officer. This thing would not have happened.
Right. Please stay with us. A mandatory test for law graduates before they can start practicing has attracted opposition from unlikely quarters, from the lawyers themselves. Almost all the state bar councils are now working on a joint protest. The Bar Council of Punjab and Haryana and Chandigarh is holding a meeting on Saturday on how to register their protest. The council has said that Bar Council of India was interfering in the functioning of the state bar councils as enrollment was their domain. Mr. Benz, do you think this kind of exam is really necessary?
In theory, of course, there is nothing wrong in it. We have a large amount of fake colleges, law colleges, which just give degrees. You register them, you deposit the fee, after 3 years you get a degree and you just sit in the exams. We have so many examples of such colleges. But then the problem is to sort out these colleges, to get them closed down, not to have another examination, because every examination adds to a kind of another money scandal. You earn money by examinations, and therefore you put a student into another kind of grinding machine when you can't sort out the first examination. Therefore it will come another harassment tactics, and to that extent the Bar Council of
But don't you think the need is to restructure the exam in the law courses itself rather than have another exam?
Yes, yes. Obviously, it is admitting failure that you can't close down illegal law, or I don't say illegal, fake law colleges who don't have teaching classes, you don't have faculties, they just have examining body and give certificates. You can't manage that college. Everybody knows it's happening. It's happening in UP, it's happening in Rajasthan, it's happening in all around Punjab, and maybe perhaps happening in now Punjab private law colleges also. To actually supervise them, regulate them properly, to hold that you have a genuine education system, you say let's have another examination. You can't control the old examination. Who will ensure that this examination is genuine?
Also, it kind of singles out the lawyers, because the other professionals, the doctors, the engineers, don't kind of appear in an exam before entering the profession. No?
If you recognize the degree, that's good enough. Why have another kind of circle of the same thing, another wheel in the same system?
But what do you think are going to be the repercussions of this? The state bar councils are at loggerheads in a way with the the National Bar Council.
I think the real motive of even the state bar council is suspect, because they believe that the Bar Council of India has now a centralized examination system. They will every 6 months earn lakhs of money by conducting examination, and they have not involved the state bar council in it. So basically it's about the money earned out of this examination also. Otherwise
But is this not going to divide the lawyers fraternity?
Lawyers, of course, are not liking it, especially the fresh lawyers, and moreover it actually works against the lawyers who are from poor and weaker sections, because it actually is lot of 1500 rupees for examination. It is actually too much for one examination. Why should Bar Council of India charge 1500? Why they should let the lawyers sit in the examination and let the Bar Council of State.
But Rajwinder, there is also a feeling that there is no limit to the number of lawyers. I mean, the lawyers are increasing by the year, and nobody seems to be retiring from the profession.
No, this is the reason we have very cheap legal service in this country. In USA you have another monopoly. You don't give the license only to a limited number. If so many lawyers die, then they have so much persons are given license. Then they create a monopoly with very high legal fee. This actually is an attempt, rather a selfish attempt. In this country you have actually free legal aid available. Lawyers have very low fees. That is only because lot of lawyers are able to come into.
So in your opinion, having more lawyers is a good thing?
Good thing for the general public, bad thing for the lawyers themselves.
Right. Day-to-day hearing has been ordered by the 30 Hazari Court in New Delhi from October 12 on a petition seeking cancellation of bail of Punjab Vigilance Director Sumed Singh Saini. The Punjab ADGP along with 3 others is facing charges of triple murder and disappearance of 2 family members and driver of 94-year-old Amar Kaur. Saini is facing trial on the charge sheet of the CBI for the abduction and disappearance of Amar Kaur's elder son Vinod Kumar, his brother-in-law Ashok Kumar, and the family driver Mukhtar Singh from the Punjab and Haryana High Court complex on March 15, 1994. Finally, Rajwinder, it appears the court has taken a very serious view. So is this a welcome step?
Very welcome, very welcome. In fact, people will lose faith in the judicial process if such a case doesn't see a logical end.
But what exactly does the day-to-day hearing entail?
Day-to-day hearing means that the defense counsel will not be able to delay on any excuse. Earlier, the basic reason why influential people are able to delay trial is that they all kind of excuses by the lawyers, by the persons, by the accused, they are sick, medical certificate, etc. And influential persons are able to delay it endlessly. And this has happened in this case also. We know the inference. Therefore, when a court says day-to-day means it will not be able to, you will not be able to delay. You have to change the counsel, all excuses are gone. Now every day evidence will be recorded, and if a case goes day to day, it can't really extend more than 2 months or 3 months maximum.
So do you expect a decision in this case in the next 2 or 3 months?
Yes. In fact, Mexico trial, Supreme Court made day to day. It is ended in 2-3 months only. Otherwise, it takes 10 years, 12 years, where there are 100 accused. So this is the way. Day to day means the moment you have day to day trial, it simply can end in weeks.
But instead of making these cases day to day, can't the court make all cases, and especially the important cases, time bound?
See, even if make a time bound, and if the accused are on bail, how will you control their movement? Either you keep all the accused in jail, don't give bail to anybody, then the trial is fastened. The moment the accused goes on bail, he then tries to delay it. He knows by delay evidence will be lost. So every accused tries to delay the trial. So one way is you don't give bail, have a faster trial. But in case you're giving bail, then perhaps the only way is when the court says, okay, you have a time bound system.
But do you think now, since the court has ordered day-to-day hearing of this case, Mr. Saini should be allowed to continue as the Vigilance Director in Punjab?
That was an issue before the Punjab Haryana High Court also, that this is actually a strange, you are a vigilance chief for the whole of state of Punjab, and you are yourself facing very serious charges. The propriety of it was always questioned. Even the new police act says such a sensitive post, you don't have tainted police officers. But in spite of that, the Punjab government wants him to continue. Reasons are very obvious.
What are the obvious
reason? Is if you have officers facing charges, you can control him. It's quid pro quo. The government will protect him, and he's under strain. Then he can't actually again go for law against the government's whatever they want him to do. That becomes a pliable officer. All these officers who are facing serious crime, without government help, they're not able to delay the whole thing. They are unable to influence the witnesses. Then they become pliable. The government wants such officers.
So is it high time that the Punjab government now finally takes a call, removes him from this sensitive post?